Well, Henshaw here again, Constitutional Crisis Channel, and I've been asked a question, about why we need bar associations, whether that be the ABA and or your local state bar association, and that's a really good question. And those of you who've gotten some of my paperwork will read it, and you'll see what I think about that. But the problem we have, especially with the quote unquote state bar association, in a situation where my records, research, and analysis, and my records prove there are no states. How can you possibly have a state bar association in something that's not a state? That's an obvious contradiction in terms right off the start. Number one. Number two, since I can prove we're in territories, and these attorneys that belong to these state bar associations now are required to be appointed by the president pursuant to Article 2, Section 2, Paragraph 2, or in the alternative, appointed by a territorial governor under the same provision of the Constitution. And for those of you wondering, no, Moonbeam Jerry Brown does not qualify here. If you haven't been appointed, that's a major structural jurisdictional error. And they're the ones who are not qualified to practice law without a license. Not us. Them. Not only that, they have an irreconcilable conflict of interest, and maybe more than one, because the issues that I advocate and I'm teaching you to use in your cases directly challenge the hegemony of the malevolent monopoly of the state bar on the practice of law. How can they possibly advocate for you when they're going to raise issues that will put them out of business? Oh, and this is equally true of the ABA, to a lesser extent, since they're not under the disability. I'm just talking about what they quote-unquote state bar association, but they have them too, and they're just not going to do it, number one. Number two, even at this point, after decades of being on the front lines, I'm not sure whether most of these attorneys simply don't learn this stuff in law school or they actively conceal it. And I don't know which is worse. But in pure point of fact, you can look around all you want for cases in just about any court, the Supreme Court of the United States in particular. You'll rarely see issues like this that have come up to the court for the decision, especially in the last 100 years or so. Now, there has to be reasons for that. And as I said, we're going to have a whole tape on, maybe more than one tape, on a case called Ashwander versus Tennessee Valley Authority, 297 U.S. 288, that discusses the court's self-declared status for doctrine for status and standing in that court. They have 7 rules. A key one here is number 1, that says that the court will not anticipate a question of constitutional law in the advance of the necessity of answering it. And they know damn well the members of the Supreme Court bar are not going to ask the questions. The fix is in. We have to do it ourselves. Fortunately, our Constitution gives us the full power and authority to do it ourselves without their assistance. And if and when I do get there myself, I'm going to flat out refuse any counsel. I'm going to say not only what I just told you to them, but I want to be here myself and confront you, and we'll go back and forth in oral argument and see who has the best of it. Now you're going to be talking to somebody who may know a bit more law than you do, and I would love to get that in the headlines of the Washington Post and the New York Times. So we'll see how that part works out. But nevertheless, the bottom line is, there's no need for these state bar associations at all, and no need for attorneys. And the other thing I didn't tell you was the attorneys are also officers of the court, and they make a general appearance that grants the court, quote-unquote, jurisdiction it probably cannot get in any other way. So what do you need these bastards for? I mean, wow. If someone came up with a good answer to that question, I would love to hear it. And I direct that especially to you members of the State Bar Associations here. Please tell me, why on earth should we consider giving any assistance from you when that's a death knell to the rights secured by the Constitution? I'd love to hear it. But hopefully this video has been helpful. Maybe the light's going to begin to come on here about the real problems in the system. But my final solution to this is we don't need state bar associations at all, and you don't need attorneys. End of tune. Thank you. Now, continuing our video on the state bar associations, why do we need them? Maybe the best example of why we don't need them occurred after the quote-unquote ratification of the non-existent 14th War Amendment. And the first 700 or 800 cases that reached the Supreme Court of the United States under that amendment, and you would think, oh, a great amendment is going to help all the little people and help make the freedmen educated, contributing members to society. 700 cases that reached there. Of those 700, 8 were pursuant to rights of the newly freedmen and slaves. The rest of them were jumped on by corporate attorneys for the big fat cats in New York, around 120 Broadway, New York, New York. That's the real agenda right there. And they didn't tell you that. But those numbers speak volumes. And I've got an official source for that if you send me a request, I'll send it back to you where I got that from. 700 cases. 1% of them were about the rights of freedmen. 1%. What does that tell you? Thank you.